Thank you. We're here in our case 1CACV 21-0021, Batty versus AZ Medical Brd. Each side will have 20 minutes to present their argument. Appellant, you may reserve any amount of that time for rebuttal as you see fit, but you'll have to keep track of the time yourself because we're asking you to argue from your table. Our clock for you is still at our main podium. Feel free to move around during the argument to keep track of the time. We won't be bothered by that at all. We are recording the argument, so when it's your turn, please identify yourself and your client so that we can keep everybody straight when we review the argument. In a couple of days, the video will be on YouTube, so you'll be able to see how well you think you did. We've read the briefs, we've conferenced the case, we're familiar with the facts and the law, so when you begin your argument, just launch right into what you would like for us to know. Counsel, you may begin.
Thank you, Your Honor. Good morning, Your Honors. My name is Andrew Bredington, and I am counsel for Appellant Dr. Trent Barry. May it please the Court. The issue here is not whether Dr. Batty committed unprofessional conduct. He's not challenging the other unprofessional conduct finding. As is evidence in the record, he accepts full responsibility for those inappropriate boundary violations. The issue is whether those boundary violations were sexual in nature such that he committed sexual misconduct. Now, the lower court of appeals, or LCA, held that the board's decision that Dr. Batty committed sexual misconduct with a patient was supported by substantial evidence. However, how could this be true when Acumen, the board's own expert, tasked with performing a psychosexual evaluation, found in two separate evaluations and written opinions that the behavior was not predatory or sexual in nature? Instead of looking at those opinions and relying on them, the board instead seemingly relied on its own subjective belief about the conduct, which is the same trap that the LCA fell into. And this is why objective expert opinion is important in this area. We provided multiple cases that show that when we're looking at issues of behavioral health, social issues, expert objective evidence is important. And I think the text messages provide a very compelling example of this. The patient felt these texts had sexual overtones. Board staff felt that they kind of were sexual, but Acumen determined they were not. Acumen determined that these were more like messages between brothers or college students.
Well, so are you saying that unless your client or a doctor subjectively intended the messages to convey some sexual interest or sexual content, that they're not sexual in nature, even though an objective observer would perceive them as sexual?
Yes, Your Honor, that is exactly what we're saying. Content can be sexualized without being sexual in nature, in that it was not done for a sexually motivated intent and purpose.
And does the statute require that? Does the statute require that the fact finder consider the intent?
We believe that one of our second argument is that intent should be read into the statute to avoid disparate opinions. I have a good example which helps kind of understand that how someone can have sexualized content without being for a sexual purpose. I have two sons, 12 and 13-year-old, left to their own devices. Their communications are littered with references to genitalia, to sex, to ejaculation, to masturbation. I have learned more vernacular terms for male genitalia than I ever knew. However, although these messages have sexualized content, they are not done for a sexually motivated intent or purpose. Therefore, they cannot be done with, the conduct was not of a sexual nature. I note the statute talks about verbal conduct or physical contact of a sexual nature.
So Counsel, why would we go anywhere beyond the statute's plain language? Why would we go down the road of implying intent? It sounds like you're asking this to take the role of the legislature here.
Your Honor, I think the argument, well, first of all, the argument is that the decision could not have been based on substantial evidence when the board's own experts said it was not of a sexual nature. And
Up to that point, didn't the acumen actually say, but ultimately it's the board's call?
They did say it was the board's call, but the case...
Would they have to? Are you aware, is any expert ever binding on any tribunal, or it's binding?
I'm not aware of the expert being binding. The position here is that we have the board ordered Dr. Batty to go to a psychosexual evaluation to determine whether or not his behavior was predatory or sexually motivated. Acumen stated in 2 separate written reports that it was not, that this was puerile behavior between 2 frat boys. This opinion was joined by 2 other experts, so you have 4 experts that said it wasn't in sexual nature. Yes, the board ultimately had the fact-finding decision, but that decision has to be based on the facts before it. And when you look at the facts, you have 4 experts that all say this wasn't sexual in nature, and you have a couple of subjective opinions.
When you say they said it wasn't sexual in nature, you're saying there was no intent. You're tying those 2 together, that the experts said there was no intent.
For something...
predatory intent.
So for something to be of a sexual nature, for verbal conduct or physical contact to be of a sexual nature, it necessarily must be done with sexually motivated purpose or intent. So the phrase of a sexual nature, implicit in that, it presupposes that the person acted with sexually motivated intent.
And what authority do you have for that?
The authority that, by the plain language of, I don't know how physical contact of a sexual nature can ever be done unless it is done with sexually motivated purpose or intent. So this is one of those implied, that a mens rea is implied here. You can't do something of a sexual nature unless what you're doing is done for some kind of sexual gratification or arousal. Case law in multiple other arenas that we cited bears this out. We have case law in employment discrimination, in insurance defense, criminal statutes. All of these different areas all require intentionality. If you look at the actual words in the statute requiring somebody to engage in verbal conduct of a sexual nature, to make physical contact, you cannot do something of a sexual nature unless it is done for sexual purpose. I go back to the example of my sons. It's littered with the exact same language here. They're not communicating for purposes of sexual arousal or gratification. They are joking with each other. I think if there is not an intent requirement that is implicit of the requirement that the conduct be of a sexual nature, then we run into the issue of the statute being void for vagueness, because it doesn't give a licensee any indication of the kind of behavior that the statute is designed to prescribe.
How so, Counsel? Because it seems like, to me, I'm reading this as more of a bright line rule than bringing in subjective intent into the equation. And you're going to determine on a case-by-case basis the doctor's intent, as opposed to here, it's do not engage in this type of conduct. Do not engage in what the ordinary meaning of the term sexual is. I mean, touching and talking.
But our argument is that this isn't the ordinary term of the definition. I'm sorry if I cut you off. You referenced the ordinary definition of the term sexual. Our definition of the term of a sexual nature requires sexual intent. And I'll give you a couple of examples on how this can be misread. Will a licensee get into trouble for sexual misconduct for inappropriately telling dirty jokes to a male patient when the jokes, although they have a sexualized content, were not made for a sexually motivated purpose? The example we gave in our briefing, and this is a true story, a male doctor accidentally brushed the breast of a female patient. She accused him of sexual misconduct. It turned out he was homosexual. He had no intent, so that is why there has to be this intent requirement for uniformity of application, and because something cannot be done with a sexual nature, or something cannot be of a sexual nature without a sexual intent. Reading.
But doesn't that example, by its very nature, distinguish it from what we had here? I mean, the doctor in the example you just gave did not intend to touch the woman's breast. So, but I don't think there's any suggestion here that Dr. Batty did not intend to send the text messages that he did, or that they were phrased the way that they were. Is that correct, or am I mistaken on that?
No, that is not correct. What our argument is, and it is an argument that is supported by 4 different expert opinions, is that while he intended to send the messages, we're not arguing that this was accidental behavior. Yes, it was intentional behavior, but it was not done for a sexually motivated intent or purpose. It was done for puerile, juvenile reasons, which were very inappropriate, but they were not sexual misconduct.
Okay, but back to what Judge Brown was saying, Honor, to further extrapolate on what his questioning was, does the statute itself, does the regulation itself require a specific finding of intent? Does it say that predatory actions are what constitute sexual misconduct, or does it just say sexual in nature?
It says verbal conduct or physical contact that is sexual in nature.
Correct.
And something cannot be sexual in nature unless it is done for a sexually motivated intent or purpose. Something can have sexualized content, but it's not for sexual arousal or gratification.
I don't see that in the statute.
It's not in the statute. Sometimes you have to infer a meaning. I know in the criminal law, I want to say 13702, it says that if a mens rea is not present in the statute, it may be inferred if the behavior at question necessarily requires some level of intent. That is the argument here. For something to be of a sexual nature, it must necessarily require that it was motivated by for sexual arousal or sexual gratification.
Well, I'm confused by your word for raising this argument, because it seems a physician needs to notice not to do the kinds of things that are discussed in the messages. And I don't see how that is avoided. So the doctor thinks, oh, I can touch the person's penis as long as I don't do it for purposes of arousal. That seems very odd to me.
I think you have to look at the result of the sanction. Here we have a board order that is a public record that anyone can go to the medical board and look up. And in that, it says that Dr. Batty committed sexual misconduct with a patient. This is stigmatizing. He has already lost various health insurance contracts with this kind of thing. He has been stigmatized for something that there is insufficient support in the record. It has, for something to be of a sexual nature, it must require sexual motivation. Acumen, who did the psychosexual behavior, talked repeatedly in its report about lack of sexual motivation. The board's evaluator tasked with determining this implicitly read a sexual motivation element into this, because something cannot be of a sexual nature unless it is done for a sexually motivated purpose or intent.
Counsel, doesn't it strike you that there is a way to harmonize that, and that is just that even that commentary, conduct, verbal or physical, between doctor and patient that involves sexual content that is non-therapeutic, non-treatment related, is just per se inappropriate. Do you make room for that possibility?
Yes, but there are other unprofessional conduct. For example, the provision that he is not questioning, that was found, he was found to have committed unprofessional conduct by committing any conduct or practice that is or might be harmful or dangerous to the health of the patient or public. Now, we could argue whether or not his conduct was dangerous to patient health, but he was found, and he's not questioning that violation. Our argument is not that what he did was not inappropriate. Yes, it was wildly inappropriate. As Acumen and the others said, this was very inappropriate to somebody who has boundary issues for various different reasons explained in the reports. Yes, it was inappropriate, and this unprofessional boundary violation appropriately sanctioned him for that behavior. However, his behavior was not sexual misconduct because multiple experts said it wasn't of a sexual nature. So because of that, we ask that
Counsel, correct me if I'm wrong, but Acumen never said this doesn't involve sexual content, right? Acumen doesn't deny that items that relate to sexes or physiology related to the sexes was not referenced or discussed. Is that correct?
That is correct, and that's exactly the point, Your Honor. The fact that Acumen can say this is sexualized content, but it is not sexually motivated. This is sexually content, but it is not done, but it is not of a sexual nature as that term is commonly understood because it was not done for a sexually motivated intent or purpose. So you're exactly right. Acumen has demonstrated exactly why this distinction is important, that something can have content like these texts, like the analogy I gave of my sons, but it is still not of a sexual nature because it wasn't sexually motivated.
But you're not suggesting that the conversations that are taking place between your sons would be appropriate and professional between a doctor and a patient?
Absolutely not, but the unprofessional conduct has been appropriately addressed by this other provision, this generally committed conduct or practice that was dangerous for the health of the public or the patient. This provision squarely addresses it. It's a broader category. This is what he is guilty of, very inappropriate behavior. But the behavior was not sexual misconduct.
But counsel, don't you make room for the possibility as well that one particular set of conduct can be unprofessional in multiple ways? So in other words, that it can, in both instances, one act can be harmful to a patient as well as embark upon an area that the powers that be have said should not exist between doctor and patient. In other words, sexual. So can it not be at once sexual in nature and also harmful to the patient? Is that not possible?
It absolutely can be, but Acumen decided here that it did not fit both of those categories, which goes back to the board's decision that it was sexual misconduct, overlooked Acumen's decision, which frankly did say, okay, this is that, but it isn't that. This is inappropriate because it's dangerous to the public, but it is not sexual misconduct. Acumen very clearly made that distinction, and that is the same distinction that the board overlooked, that the LCA overlooked, because they applied their subjective opinion about what this conduct was, and it is this error that we're asking this court to correct.
Counsel, can you point to me in the record where the Acumen report says it's not sexual in nature? Quote, quote, not sexual in nature.
I can.
Acumen concluded the evidence pushed this into poor professional boundaries and interpersonal judgment rather than sexual misconduct. They also said that overall the nature of the text messages resemble those between two college students or messages from a peer or older brother rather than being sexual. Acumen concluded, and so this is page 14 of our first brief, and we are referenced in the first Acumen report, which was our Exhibit 2 in the appendix. Pages 2 to 3, they conclude the text messages reviewed on Dr. Batty's phone, and there's some ellipses here, do not contain any sexual advances, and there does not appear to be any predatory or sexual advances embedded in the messages, and then later talked about how it's students rather than sexualized.
But that's not what I asked for. I asked, where does it say it's not sexual in nature? What you told me is that it's not predatory. I accept that. I'm asking you where it says that it's not sexual in nature.
In the second report, which we attached as Exhibit 5 to our appendix, on page 1 here, it says that his polygraph results demonstrated the absence of any sexual misconduct, and that they referenced the boundary violations as non-sexual boundary violations in the past with patient. That is on page 16 of our brief, referencing Exhibit 5, which is the second Acumen report. I have a minute left. I'd like to reserve that for rebuttal if I may.
Yes, thank you. You're welcome to. Counsel?
Good morning, and may it please the Court, Assistant Attorney General Michael Rain on behalf of the Arizona Medical Board. Back away. Dr. Batty's appeal is based largely on his misrepresentation of Acumen's reports. There was another evaluator, Dr. Becker, whose reports Dr. Batty has also misrepresented. I think the clearest example of that is the exercise that Your Honor just put counsel through, where you asked him to show. Where does it say in any of these reports that it was not sexual in nature? And counsel read from the brief where it says they indicated they were not sexual in nature, but then could not replicate that when looking at the actual reports.
Let's assume for a minute that Acumen did say it. Just assume. Does that change? Does that really change the board's ability to find the doctor responsible for unprofessional conduct and for engaging in sexual conduct?
Well, I think it would be a factor in the board's factual determination. As a regulatory board made up primarily of professionals, the case law says, I believe it's the Lathrop case.
In other words, I'm asking if that would be binding on for dismissal.
And that's where I was going. Under the Lathrop case, it's not cited in our briefs, but there's other case law as well that says these boards don't need experts. They are experts. And I'm not quite familiar with the trial judge's authority, to weigh the testimony of experts. In any given case, you're going to have two experts often saying exactly opposite things, which just goes to show I don't think any trial court's bound to accept any expert merely because they are an expert. But in this case, that is hypothetical because neither of these experts did say that this conduct was not sexual in nature. How could they? Dr. Batty discussed intercourse, masturbation, ejaculation, sexual frustration, sexual gratification. These are all clearly items that are sexual in nature, which, as Your Honors have all noted, is all that the statute requires. But I think you can go even further. When you look at Acumen and Dr. Becker's reports, they don't conclude that it wasn't sexually motivated. That is also false. As we've noted, Acumen says we're not deciding it. What Acumen says at one portion, which is quoted in the briefs, that certain factors in their evaluation, quote, pushed the evidence towards the conclusion that Dr. Batty was not sexually motivated. Immediately following that statement in the report is their commentary about, but we're not the decider. I mean, that's for you to decide. There were some factors that pushed the evidence. Dr. Becker's report, and Dr. Becker was an evaluator that Dr. Batty obtained outside of the board's investigation, she said that issues of sexuality may well have motivated Dr. Batty's conduct. And so even within this record, under the standard of review for substantial evidence determinations, there's evidence in the record that he was sexually motivated. So that is just the foundation of their case, and it is quite shaky. When you read those reports closely, they don't say what Dr. Batty says that they say. And I think any person of reasonable intelligence under a vagueness standard knows those comments. Dr. Batty's comments were sexual. There may be innuendo, there may be accidents, mistake, lots of reasons that you might look in a different hypothetical case that just aren't present here, where you might see something maybe objectively sexual that you could pull out of that because of the context. There's nothing here that suggests that should be the case. Dr. Batty addresses this subjective standard he thinks that the trial court and the board applied. But as Your Honor noted, and I believe Judge Howe, you noted as well, are we just going to make every case depend on the subjective state of mind of a doctor? Let's place this this victim, the patient, into this conversation. If one patient, Dr. Batty, reaches over during a car trip and touches the patient's erect penis, as he says, purely for his own joy, for his fun, just poking fun at the kid. Are we going to tell that patient, well, I know you felt violated. I know he touched your penis because it was erect, but Dr. Batty didn't mean it that way, so he can't get in trouble. Other subjective motivations for sexual misconduct could be completely non-sexual and still need to be prevented by this state. As we all know from these last several years in the public eye, Me Too and all of these issues, that sexual assaults and other sexual misconduct can be for many purposes, for control, for intimidation, completely non-sexual, with no intention of ever consummating a sexual relationship. And we can't say, well, it's okay as long as it wasn't intended to actually consummate or be an advance of towards any sort of sexual relationship. That is not the law. As Your Honor noted, the legislature decided to draw a bright line. Doctors may not engage in verbal and physical conduct with a patient that is sexual in nature, period. Counsel described the situation of his sons, and it's a kind of a red herring. His sons aren't physicians. They haven't subjected themselves to this limitation on their conduct for the protection of any patients. And that also addresses some of the vagueness critiques. When you look at the standard, and in Dr. Batty's briefs, while they say it's void for vagueness, they never actually make an argument about that. They just kind of conclude that and cite a case. But when you look at Village of Hoffman cited in our briefs, they list a number of factors when you look at void for vagueness. And one of them, the primary one, is that it's civil, and there aren't criminal penalties that you would have to undergo just to find out the ends of the statute. It's a civil case. You can go through a civil process. But more to the point I was making, these are physicians. They are trained, they are experienced, they have continuing education requirements. I think this case presents a good example of how a party could learn the boundaries of their conduct. Dr. Batty has indicated his own appreciation of how his misconduct was wrong. He's spoken with professionals. He's been asked, and he's willingly and happily worked with outside resources. He formed a boundary protection plan. He has, there's practice monitors, there's chaperones, there's all kinds of things people can do to improve their awareness of the boundaries of their conduct. This case doesn't really present a boundary issue. A boundary of what's appropriate issue. It definitely presents boundary issues. Dr. Batty was far over the boundaries. That is what the experts found, both of them. And the board didn't ignore those experts. The experts were there to provide fitness to practice opinions. It's clear from their reports that that's the purpose of Acumen's report, the board's ordered evaluator, and that they weren't there to be fact finders. And that's demonstrated by their recommendations.
Can you elaborate just a bit more on that, fitness for practice? In other words, that if I understand that correctly, that the board wanted to know, should this doctor be practicing, period? Should he be continuing to have patients engage in the practice of medicine along those lines? Is that what, is the board concerned more of that in the first instance?
Yes, Your Honor. I won't try to flip to it in my report. I do understand, I do recall that we cite this in our brief portions of Acumen's report where it describes its role as one for fitness to practice. The board entered what it called an interim order for evaluation. And you see that, I guess another example of that being their role is their recommendations and their conclusions. Dr. Batty is not a predator. He is not a terrible human being. They determined that he could be safe to practice if, and then they listed out a litany of things that he should do in his practice to remain safe. Similarly, the board did the same at the end of its order. But within Acumen's report, they do identify the scope of their role. Outside of the record, as it may be, our experience with this is is that's what the boards do, is they send these out for fitness for practice determinations. I don't think I'll be able to find the board's interim order. I know it's cited in our statement of facts. I can't tell you as I sit here whether it literally says that in the board's order that we're sending you for a fitness to practice evaluation. But that is essentially the purpose, and you can see that through Acumen's reporting.
What's your response to the argument that sexual motivation and intent must be inherent in the term sexual conduct because it's required in other areas such as mens rea for criminal statutes?
Yes, Your Honor. I would say, number one, as it pertains to sexual harassment cases, there was sexual harassment and criminal were their two analogies, and that's just not the law. The cases that they cite do not say that you need sexual motivation. And of course, again, you can be in the workplace and use sexual conduct that is sexual in nature towards an employee for purposes other than sexual gratification. Of course you can. Intimidation, all kinds of other purposes. What the cases that the appellant cites say is that it has to be sexual in nature, just like the board statutes. And then when you look at the criminal law, I think the point I'd like to make most there is that the standard for doctors is not, do not commit criminal sexual assault. That's no standard at all. They don't need their own statute. That's already against the law. And of course, I think we can all assume that the legislature, has wisely said, doctors, we're going to hold you up to a higher standard than unwanted sexual conduct for sexual gratification that would rise, to potentially criminal conduct. There is some authority that appellant cites that, the board statutes are quasi-criminal. I don't think that's been resolved anywhere, but the point of treating anything as quasi-criminal is for the level of due process that you might provide in an adjudication. We cited the Henry Brady case. It was a bar disciplinary case where they discussed those issues. That doesn't mean you take the substantive elements of a criminal law statute and use them instead of the statutes that have been cited in the board's order. So to the extent there are those mens rea requirements in the criminal law, there's no mechanism to just insert them into the board statutes.
And as I understand it, sexual motivation isn't required for proof of something like sexual assault or anything like that.
I don't know the answer exactly to that. I could tell you that for the reasons I've already said, my supposition is you're going to be guilty of sexual assault if you happen to commit a rape for the purposes of intimidation. I don't think they're going to ask and depend upon the protection of the public. What was your subjective state of mind? Especially with Fifth Amendment issues where you might not even have to say what your subjective state of mind was. So it's just not really the law in at least the sexual harassment case. I can't tell you the correct answer in the criminal law, but what I can tell you is that it doesn't really have any bearing on the board's regulations.
On that topic, does the rule of lenity have any application here?
That was mentioned in the appellant's brief, that you could interpret this statute in such a way, but I'm not sure that the rule of lenity requires or raises to the level of you adding whole elements to statutes. There is no ambiguity in the remainder of the board's. What's sexual in nature, I think, is something that the common person will understand.
Are you aware of any non-criminal reported decision that's actually incorporated and discussed the rule of lenity?
No, and I don't believe that the appellant cited any, Your Honor. I've never seen it applied. Ambiguous statutes are one thing. The statute's not ambiguous to begin with. It may be that the appellant thinks that the line that the legislature drew is too strict and it doesn't provide the wiggle room to tell dirty jokes in the office, but that was the legislature's choice. It's not unclear what they decided. And you see that in the remainder of the statute. There's 3 elements that can constitute sexual misconduct, or sexual conduct, I should say. And those include engaging in sexual relationships, So there's one thing. You don't obviously need to consummate a relationship. That's already addressed in subsection I or 1. Making sexual advances or requesting sexual favors. You don't always need that because that's addressed in section 2. And then also in section 2 is our provision, other verbal conduct of a physical, other verbal or physical contact of a sexual nature. So the statute itself, it belies the argument because you're going to end up rendering portions of it redundant or superfluous if you say the sexual nature provision needs an advance or a consummation of the relationship. That's already said in the statute. That would render portions of it redundant. And you also see the intent requirement that the legislature placed in the 3rd subsection, which is intentionally viewing a disrobed patient. I think that's somewhat informative because unlike text messages, phone calls, or touching, not accidental touching, but intentional touching, the eyes are a passive thing. You could imagine a doctor walking into a room and seeing a disrobed patient just because their eyes were open and the image, the light of the image hit their, I guess I don't know my eye anatomy, but it hit their eye and it translated it to their brain. And so you needed the legislature needed to make clear, you need to intentionally be viewing it. They chose not to do that when it came to the conduct that Dr. Batty engaged in. And so for all those reasons, unless your honors have any other questions, the state would ask that you affirm the Superior Court's decision, affirming the board's decision. Dr. Batty has completed his probation. The case is over. He simply does not want this stigma on his record, and that alone is, of course, no reason to overturn the board's decision. Thank you.
Thank you, Counsel.
Briefly, Your Honors, the counsel of the board just stated, and I think I'm quoting this directly, what is sexual in nature is something that the common person understands. We submit that the common person understands for something to be sexual in nature, it must have been done for a sexually motivated intent or purpose. That is the common understanding of the term. So we're not asking you to read something into the statute. We're asking you to say that that term of a sexual nature necessarily requires sexual motivation. Turning to the order, there was a question as exactly what the order for the evaluation said. I've located it. It's Exhibit 1 to our appendix, to our brief. And it actually says, it doesn't say respondent shall undergo a fitness to practice evaluation. It says respondent shall undergo and successfully complete a psychosexual evaluation at a board-approved facility. Now, and I'm reading now from page 13 of our reply brief on the scope of that evaluation. ACO made clear that its psychosexual evaluation included the opinion on whether appellant's behavior was sexually predatory. See Certificate of Record 13 at 4. Purpose of the evaluation is to provide an opinion on whether the conduct was predatory in nature. See Certificate of Record 13 at 22. Concluding appellant was not a predator and did not have any sexual compulsivity addiction issues. Therefore, this determination necessarily had to include an opinion on the sexual nature of the conduct.
Thank you, Counsel. Your time is up.
Thank you, Your Honor.
We appreciate your arguments today. We'll take this matter under advisement and we'll issue a decision in due course. We'll stand at recess. Thank you.
Thank you.
Thank you.